moderator today for today's press conference. We are holding this press conference today to talk about an email that the Acacia Center for Justice received last Wednesday, instructing a temporary pause, an abrupt pause to four programs: the Legal Orientation Program, the Family Group Legal Orientation Program, Immigration Court Help Desk, and the Council for Children Initiative. Today's speakers will talk about what the pause in these abrupt pause in these programs mean for the clients that they serve, our rule of law, and our immigration system generally. Our first speaker today is Michael Lukens. Michael Lukens is the executive director of the Amicus Center for Immigrant Rights. He has been with the Amicus Center for the past 10 years and oversees Amicus work with adults and children held by the government and facing deportation. Michael, please go ahead.
Good afternoon, everyone, and thank you for joining us. We're going to talk today, as mentioned, about the Legal Orientation Program. We probably also will call it LOP because we slip into initialisms. I thought I would take a few minutes and put some context around what my brilliant colleagues are also going to talk about, which is what these programs are. Legal Orientation Program is the most basic due process that could be afforded. It is not representation in courts. It is providing people who are facing deportation with know your rights, with an orientation about what's happening to them, giving them a sense of where they are in the system. And this is a program, there are four parts of this, and I'm going to talk about the LOP and detention, which is what Amicus Center does. So we go into detention centers where adults are being held by ICE, and we do these orientations. This is not a new initiative under President Biden. It's been around since 2003. And on any given day, you have between 30, 40,000 people detained across the country, and nonprofits are going into these detention centers to provide this very basic service. And last week, we received notice of a stop work order, meaning that Department of Justice would no longer be funding this type of work. Our team at the Amicus Center still went to the detention centers the next day, because even in the past, when there has been shortage of funding, stop funding notices, we go in because that's what we do. We help people. That's our mission. And we were told that last Thursday to leave the facility. Our team was there. They were helping. We were not getting paid to do so. And the facility told us we had to leave because of an ICE directive that we would no longer be able to provide this type of orientation service. You know, we don't do this to make money, obviously. We do this because this is what all of our mission-driven organizations are focused on across the country. And to be told that we can't go in and help people is devastating. Devastating to us. It's devastating more so to the people we're trying to help, who are being cut off from the outside world. We often hear that people don't know what's happening. Why are they detained? What is going to happen next? And we're being stopped from even getting that basic level of orientation. So we're going to see detention go up. You know, this administration has made very clear that it wants to mass deport as many people as possible. Well, mass deportation starts with mass detention. And if you have detention numbers going up and nobody to help, you're essentially setting up black sites around the country where there is no rule of law, where there is no transparency or accountability. And this is just unacceptable. So I'm happy to answer lots of questions as we go along, but I wanted to give you that very basic detention and overview of what's happening.
Thank you so much, Michael. Our next speaker is Azadeh Irfani. Azadeh is the policy director for the National Immigrant Justice Center, which is dedicated to ensuring human rights protections and access to justice for all immigrants and asylum seekers. Before working in policy, Azadeh provided legal services to adults and children facing deportation. Please go ahead, Azadeh.
Thank you so much, and thank you everyone for joining us today. My organization, the National Immigrant Justice Center, is headquartered in Chicago and provides services to about 11,000 low-income immigrants, refugees, and asylum seekers every year. For nearly a decade, part of our work has entailed providing free legal orientation and advice at the Immigration Court in Chicago for unrepresented individuals and families that are facing deportation proceedings. We've done so as a federally recognized immigration court help desk provider, which is part of the services that have been cut off by the administration as of last week. Up until last week, when we were forced to end our work, we worked collaboratively and with the full support of immigration judges and court staff who understood that our services were filling a vital gap. It's the norm, not the exception, that most people lack the time and financial resources to retain an attorney and help them with their immigration case. Consequently, the help desk is working with immigration courts to provide information to individuals about the process in immigration law, helping them fill out key forms that they need for their cases, and orienting them as to their rights and responsibilities, among many other things. The help desk enables the judges to manage their extremely busy dockets and court staff whose phone lines are always ringing with people desperate for basic information. Just in 2024, our Chicago help desk provided 3,604 unique services to over 2,000 individuals and families. This includes information sessions, workshops, and friend of the court appearances. The help desk has been a lifeline for the people we serve. Immigration law has been rightfully compared to the tax code because of its dizzying intricacy. And though the consequence of not understanding the system is much, much greater than tax liability, as it leads to permanent banishment and the separation of families. Through the help desk, NIJC has been able to identify emergencies such as imminent filing deadlines, avoid deportation orders that would unlawfully return asylum seekers to harm, dispel myths and fears, and help participants make informed decisions about their cases moving forward. In other words, it's bringing much needed clarity, due process guardrails, and efficiency to both the courts and immigrant communities. Now that the Trump administration has forced us to stop providing these services, we fear the consequences for the individuals we served. I'll just give one example, which is Ana, using a pseudonym, an indigenous woman from Ecuador who survived sexual violence, abuse, and persecution from the Ecuadorian police. Before finding the help desk, Ana had struggled to navigate the US immigration system because of her extensive trauma history and language barriers. Shortly after arriving in the US, she faced urgent hospitalization and then had a very difficult C-section birth for her first child, all while being far from her family and under the fear of deportation. Our help desk team helped Ana file her asylum application and navigate a very complex one-year deadline, which under asylum law requires an explanation for delayed filings, otherwise barring people from asylum protection. Now that the administration stopped our services, people like Ana have nowhere else to turn and could face summary deportations back to the violence they fled simply because they lacked the legal guidance and help they so desperately needed. I'll just close by saying that this is not the first time the Trump administration has tried to stop our services. They tried once in 2018 under Trump's first term and faced swift litigation and pushback from Congress. NIJC and our partners sued and helped ensure that both the help desk and legal orientation programs, which Michael mentioned, continued. By ordering the stopping services, the Trump administration is inviting another lawsuit to be launched imminently by the community of legal service providers. It is simply unconscionable to defund these services at a time where the administration is conducting mass raids and further swelling the immigration court backlog that already nears 4 million people. They are essentially robbing the courts and those individuals of the services they desperately need, and they are harming everyone from court staff, immigration judges, and impacted individuals and asylum seekers. Tossing it back to you, Bilal.
Thank you, Azadeh. Our next speaker is Abdulaziz Musa Jibril. Abdulaziz was a participant in a legal orientation program when he was detained in Farmville, Virginia. He is actually a legal scholar himself, getting a master's degree in international and European Union business law from the Sorbonne in Paris. He practiced law for a decade as a criminal judge, deputy prosecutor, and legal advisor. Abdulaziz also taught criminal law at Djibouti University. He sought asylum in the United States and was detained in Farmville and attended a legal orientation program. He's now a recent law school graduate studying for the bar and member of the Amica Center for Immigrant Rights Board. Abdulaziz, please go ahead.
Thank you so much. So I am here today, to share my immigration journey and to tell you how that was the toughest moment in my whole life. Toughest not because it was particularly painful, even though it was psychologically and physically, but toughest in a way that I was completely diminished, lost, and hopeless. I have never been in my life hopeless. As a lawyer, I always thought that I had the law on my side and that everything will be fine until I came in America. So I have arrived in America by plane, and the Custom and Border Protection officers denied me the entrance into the American territory. And they then detained me till ICE came and took me over. So ICE handcuffed me from the hand all the way to the toes, like I was the worst criminal ever, although I was just an asylum seeker. And then they detained me in one of those transit locations that they have around the DMV until they finally transferred me Farmville Detention Center in Virginia. When I have arrived over there, the detention center processed me. They handed me a yellow jumpsuit. And to be honest with you, when I saw the yellow jumpsuit, that's where literally my brain shut off. I couldn't even know where I was. I couldn't even protect myself properly as a lawyer. So I just went blank. And then I was just doing whatever those officers were asking me to do. So that's how I got processed from the airport to Farmville, Virginia. But so more I was going through the immigration journey, more I was seeing the inconsistencies through the form and through the content. And so I was just sitting at Farmville Detention Center when one of those inmates came to me and he informed me that there were those people that were coming once a week at the detention, and they were like helping people. Helping how? He couldn't give me more information. And then I went to see the officer and asked me to put my name on the list so I can see those people. And when they came, finally, I remember that day, it was a Tuesday. I still remembering like it was yesterday. And then I went to see those people, and then I talked to them. So they were there, to provide us information about how to process our case and how to go through the whole immigration processing, which is the program that is posed actually. And then they had those little session like as a group, and then a one-on-one session. And that's when literally again my brain came back, and I assessed that I was actually in a detention like a prisoner, and that I had to fight back my case. But how do you want me to fight a case if I was detained, if I am, excuse me, if I'm detained, if I don't have access to my own property, if I don't have access to internet, if I don't have access to a decent library? Literally, we were like on a no-zone area. So the only people that we had access and that we would seek help from was those, as I like to call them, those big-hearted people that were coming to us and try to help us to go through the immigration process. As you might know or not, the immigration trial is like an adversarial system. So I have, to fight against a prosecutor who he's one of those most powerful prosecutor in America, and going under Homeland Security. And he has access to like everything, basically. And on the other side, it is the immigrant, the detained immigrant, who has access to basically nothing. So how do you want that the adversarial system work? It just cannot work. So that's why I decided, after I won my case, thanks to Care Coalition then, and now Amicus Center, and I was able to fight properly my case and win my asylum, and then became, a permanent resident in America, and then went back to school, did my, law degree so I can become an immigration lawyer and help people. And so that's why I decided to join Amicus Center and fight, alongside that organization. And to conclude, I would like to say that going through that type of judicial trial without the respect of the principle of the adversarial trial was not only unfair, but it was also horrific and inhumane. If me as a lawyer, felt that way, just took 1 minute, and imagine how a person who maybe never went to school at all, who maybe had how can I say, like little education, could feel right now in detention center without the help of those big-hearted people. Just took 1 minute to reflect on that. And if I could make it, it's because, I remember this book written by an author called Irving Goffman, I guess it was, and the book was the title of the book was The Presentation to Self in Everyday Life. And to resume a little bit, this author was talking about how the whole life was a piece of theater. So wherever the moment you are in is your role in this piece of theater. So that's what I remember when my brain came back to function again because of those big-hearted people that came and talked to me and bring light to my life. So that's what I remember. And then I said to myself, listen, this is now your role to play as a detainee for a period of time. And then I will be able to get my life back as a lawyer. So that's what helped me to go through the immigration system in America. Thank you so much.
Thank you so much, Abdulaziz. We're grateful for you for sharing your story, for connecting the dots about what this abrupt pause in these vital programs mean for participants in the programs. Our next speaker is our second to last speaker before we get to question and answers for members of the press. Laura St. John. Laura St. John is legal director of the Florence Immigrant and Refugee Rights Project. As legal director, Laura oversees key programs, including Florence Project's advocacy team, as well as the adult legal, children's legal, and social services programs. Laura first joined the Florence Project in 2011 as a staff attorney, where she provided pro se legal education and orientation services under the legal orientation program to individuals detained in ICE custody. The legal orientation program is one of the programs that was paused by the recent DOJ order. Please go ahead.
Thank you, and thank you everybody for being here today. 35 years ago, the Florence Project was founded after a call to action from an immigration judge working in the detention centers in Florence, Arizona, who became deeply concerned about the lack of due process he was witnessing every day in his immigration court. The judge saw asylum seekers coming through the courtroom who had no idea what was happening to them, no information about the legal system or what was required of them in this process. And so he put a call out to the Phoenix legal community, and the Florence Project was born. In a system like the immigration court system, where there is no public defender, the vast majority of people go through the process without an attorney. In one of the most complicated legal systems we have, against a trained government attorney, oftentimes in a language they may not understand. The LOP is the bare minimum due process requires. It's not representation. It is simply providing people with the most basic information necessary about what is happening to them, what their rights are in this process, and helping them understand what options might exist for them. As Abdulaziz just said so eloquently, how can you expect someone to fight their own case in an extremely traumatizing situation with no understanding of the process and who, due to the conditions of their detention, have no access to the information that's necessary to prove their case? That's not justice. And so in recognition of this injustice, the Florence Project developed the model that the legal orientation program was based on. We were focused on educating and informing people about their rights so they can efficiently and effectively navigate this really complicated system. It was a way to maximize resources and a way to ensure that at least the basic level of due process was attained. And in a state here in Arizona where there are typically anywhere from 2,000 to 3,000 adults detained on any given day in ICE custody, the Florence Project was the only organization trying to provide any kind of legal services to those folks, and we still are. The LOP, since its creation, has always enjoyed bipartisan support, and it's been recognized to be effective. And again, the minimum requirement to safeguard due process in immigration detention. The LOP, through this project, the Florence Project legal staff deliver these weekly group orientations to help people understand their rights and defenses. We also do workshops for people around things like how to prepare for a bond hearing. And we do one-on-one individualized orientations and screenings for pro bono placement, because while very few people are able to get an attorney, having an attorney can make a world of difference, and those pro bono screenings are incredibly important. And in addition, just to circle back, safeguarding the bare minimum of due process, these programs and the work that we do really help improve the functionality of the immigration court system. When people understand what is required of them, when people understand what needs to happen next, there are fewer delays, there's fewer moments of confusion, and people are able to move forward in a way that at least begins to resemble fairness. The impact of these orders, the stop work order, has already been felt. Indeed, we've received, I'm not sure how many, if we've reached the hundreds yet, but panicked phone calls from people in detention reporting that every poster explaining how to reach the Florence Project and our materials explaining possible relief have all been removed from the facilities. We are being told by clients, both pro se and represented cases, because we do also offer representation to people, in some cases outside of the legal orientation program. We're being told by folks that the guards in the facilities are telling everyone that the Florence Project is not allowed in these facilities anymore. This is a gross overstatement at best of the stop work order, but it's also deeply concerning because it just instills this incredible fear and despair for anybody who is currently in custody. I want to share, I think, one story. We have a lot of stories of people who have been successful because of the legal orientation program. But what I wanted to share is actually a story about when I was first starting as a staff attorney with the Florence Project, and I had provided a Know Your Rights presentation under the LOP. And I met a man at the time. We were doing that right before court hearings, and so we had done the group presentation, but he still had some questions and didn't really understand how some of the information in the presentation connected to his particular case. And so I told him I would come see him after court. I would come to visit him in detention to talk through that more. When I came to see him in the jail where he was being held, before we even started talking, he burst into tears. And when I asked him why, are you okay? Like, what's going on? He told me, I'm just so glad someone came here to see me, to talk to me about my questions. I have thought about that gentleman many times over the course of my career, because no one should be locked away facing a really complicated legal matter without even basic information of what's happening to them when their life and their family and everything is on the line. But that is exactly what will happen without the LOP. And thousands of people like that man will have no choice but to face the full force of the United States government with no information or resources at all. That is just cruel and inhumane, and it is not American. And that's what I have to say about that.
Thank you so much, Laura. Our final speaker before we turn to questions from members of the press is Andrew Nietor. Andrew is a CCI provider. He practices immigration law in San Diego, California. He focuses on litigation and immigration court proceedings, including representing vulnerable groups such as those with mental health issues and children. He is on the board of governors of the American Immigration Lawyers Association, or AILA, and is a former chapter chair of AILA San Diego, and is on the board of directors of Federal Defenders of San Diego.
Well, good morning, everybody from San Diego, California. So I've been representing children in the Council for Children program, CCI, for the past 3 years, and currently represent about 20 children, and they range in age from 8 to 17. CCI is a relatively small program, helping 200 vulnerable children at any given time, which is why we're not sure why the administration would have targeted children in this particular group. Our clients are children who find themselves in deportation and removal proceedings, which can be daunting for anyone, but for these children, they're dealing with the complexities of the immigration court system. They're usually not English speakers. Children who fled their home countries and are usually without parents, dealing with the trauma of not just that journey, but also, whatever situations of abuse and abandonment they left behind in their home countries, and the overwhelming stress of now being in a new country and suddenly thrown into deportation proceedings. The attorneys representing these children are dedicated advocates. They're nonprofit organizations, often faith-based groups, who step in to help them with the immigration court system. And that can be anything from sitting next to them in court to reviewing their cases to figure out what they might be eligible for, helping them fill out those complex forms, asylum applications, reaching out to help find guardians, coordinating with other social service providers like social workers, mental health experts, and other experts, many of whom provide their services pro bono or at reduced cost. With the stop work order on Tuesday, it risks leaving hundreds of children in the lurch right now, and many more going forward, left to somehow sort of fend for themselves with no legal support. It puts many of the nonprofit groups in a difficult situation, having received those orders with no notice. As attorneys, we've already established attorney-client relationships with these children, and we have an ethical duty to continue to represent them. But with that abrupt order, many of the groups suddenly face an end to any funding, but with an ongoing duty to continue representation. And while we want to continue working on these cases, we have no further financial or logistical support, no funding to work with other service providers like doctors and interpreters and other experts. And of course, it means that no new cases can begin, no new children can be helped and made part of the program. One final thought that I think is important to highlight is having counsel for children makes the proceedings not only fairer, but more efficient. And that means less delays, less continuances. When an immigration judge walks into a courtroom and sees an 8-year-old at the table, as you can imagine, the judge would certainly prefer to have an attorney step in. Because otherwise, those cases are going to be exponentially slower with multiple continuances. And the judge is really having to figure out how to walk that thin line between being a neutral adjudicator and making sure the child understands what's happening, what they might be eligible for, and then correctly complete these complex applications and supporting document submissions. So CCI was a program that was widely supported by not just the immigration bar and other advocates, but by the courts and the judges themselves. It also occurs to me, thinking of what everybody spoke about this morning, the attack on programs like LOP and CCI is problematic on its face, but it's also important to look at the stop work orders, not in isolation, but together with some of the other executive actions that we've seen implemented in the past week. So things like elimination of sensitive locations policies that now directs ICE enforcement officers to enter hospitals and schools and churches, and suspension of all refugee programs, including for Afghans who worked with U.S. military and are at risk of persecution, termination of CBP 1, which impacts asylum seekers who were following the rules and are now stuck in Mexico. They've been stuck in Mexico waiting for months for an interview and are now left with no options. And I think when you look at all these policies together, they really belie the administration's rhetoric about prioritizing public safety and targeting people with serious criminal history, and demonstrate that they're ultimately targeting the most vulnerable groups. And I'll shoot it back to you, Bilal.
Thank you, Andrew. We'll take our first question from Felipe de la Hoz. Felipe, if you want to come off mute. Thank you. And as a reminder, we're taking questions from members of the press. Just raise your hand to join the queue.
All right, thank you all for being here and putting this together. I have a couple of questions. One of which has to do with, in one of the executive orders issued last week, the government kind of made explicit the idea of kind of encouraging voluntary compliance with the law, I think is what they termed it. Basically, I think making it clear that one of the objectives is to sort of get people to, I think, not fight their cases, right? Not actually sort of, accept the avenues of relief available to them and to kind of, accept orders of removal or voluntary departure. Just to kind of ask something explicitly that might be obvious, is it your understanding that this suspension of these programs is at least in part an effort to sort of not just gum up the works, but make people not pursue their cases altogether? And then just the other question is somebody mentioned possible litigation about this. I'm just wondering in very broad strokes if you could sort of give us a sense of like what the maybe statutory basis or under what kind of rationale you might seek litigation to force the overturn of this order. Thanks so much.
Yeah, those are both great questions. I'm going to go in reverse order. I want to be careful. I mean, there is litigation that we are exploring. We obviously don't want to signal ahead of time what exactly that will look like, but there are a number of constitutional and statutory claims that we are exploring, everything that we looked at the last time when this happened. So I don't want to get in front of that litigation, but hopefully that will be filed imminently. To your second question, yes. I mean, the executive orders make clear that this administration is not only trying to militarize the immigration system, but also trying to make people's lives that are just living in the United States difficult so that they will decide to not fight their case or to leave the country. And as Azadeh mentioned, we have been able to do this work without funding before. The fact that we can't does make me think that part of this is to scare people who are already scared from being in detention, to get people to get to what we would call detention fatigue, being isolated from your family, from your community in a jail setting is incredibly traumatic, and further isolating them will, I am sure, result in people choosing to not fight their cases.
Can I just add on a quick reminder there too, also though, because I think some of the language that was used was sort of, trying to force legal compliance. And I would just remind everybody that the United States government also has legal obligations, and that people who are fighting their claims have legal rights to fight those claims. An asylum seeker has a right to be seeking asylum. And there's a really concerning sort of rhetorical turn there to try to pretend that forcing people to give up their claims out of desperation is in any way tied to complying with the law, because the law gives people these opportunities.
And just another,
Powerful. Go ahead.
sorry, just another footnote on that, which is that immigration judges also have a duty to preside over fundamentally fair hearings and develop the record. That's nearly impossible to do when people are not informed about how the system works. And just one other thing, which is that, when people are in jail and immigration jails, they're often being pressured on a daily basis to sign deportation orders. So essentially, by stripping away legal services, you're also exposing them more and more to that risk of self-deportation as a result of that detention fatigue and desperation we all mentioned.
Thank you. Our next question is from Alyssa Resnick from KJZZ.
Hi, everybody. Thanks so much for hosting. Wanted to ask you about another ICE memo that came out at the end of last week regarding the use of, or folks who are here in the US under temporary protection, like humanitarian parole. So Haitians, Nicaraguans, Venezuelans, Cubans, as well as people who entered through CBP-1 being potentially now available for expedited removal process. I'm curious, especially for people who are already awaiting immigration court dates, say people who entered through CBP-1, is that something that legal representatives are talking about now in terms of what your options now are for those clients? I mean, is it possible, I guess, put simply, to enter someone into an expedited removal process who is already awaiting an immigration court date for the merits of their asylum claim?
Happy to respond, though. The Florence Project, we focus on detention work, and so most folks who would have come through CBP-1 and have been paroled in and issued a notice to appear to start removal proceedings in that way, we generally have not seen them thus far. But the memo does explain that there's a procedure by which ICE can move forward on essentially eliminating the notice to appear, moving to dismiss it as improvidently issued or otherwise, and potentially place people instead into expedited removal proceedings. So that is a very real concern.
The thing that a lot of providers are talking about is the possible return of MPP remain in Mexico. And so there is a way to, have it both ways. They could allow people to continue to pursue their cases in court, but essentially expel them from the United States and force them to wait in Mexico the way they did under the first administration. Again, in horrible conditions and essentially refugee camps along the border in Mexico, perhaps in hopes that they will be discouraged and give up their cases. So it's possible that somebody could be subject to expedited removal, even if they do have a case in immigration court that remains active, but just not allow the person to remain in the United States while they fight their case without access to their attorney, access to family, and really just make it a miserable experience for them, similar to the question that was asked just a few minutes ago.
Thank you. We have Elvia Malagon from the Chicago Sun-Times.
Yeah, this question was a little bit more geared towards NIJC. I wanted to, some of the other programs talked about how, they were like physically told they couldn't be inside of a particular building or facility. I wondered if that was also happening at the Chicago Immigration Court since the stop work order stopped or was issued. And then wondering if you or anyone else could talk about in terms of like the funding that DOJ was providing for these services, any idea for how much it was for like the past fiscal year or anything like that? Thank you.
Thank you for that question, Envia. So the stop work order was pretty unequivocal in terms of our capacity to return. With that said, if we had ongoing relationships or had already begun work on behalf of a client, that is something that we've had to determine on a case-by-case basis. But in terms of returning to the court as a help desk provider, that is not something that we've been able to do as a result of the stop work order. In terms of the funding allocated, that is something that I'll have to just double check for you. I'm happy to follow up afterwards.
Thank you. And then we have Chris Johnson from CQ Roll Call. Chris, can you unmute yourself?
Yeah, thank you for hosting this call. I had a question about a related issue, actually. As we're seeing the administration begin its work on executing its plan for deportations, there appears to be a heavy reliance on the military. I am just wondering if any of the attorneys on this call could speak to any of the issues that they see with that.
So let me say up front that is an incredibly complicated issue, especially legally. Some of these laws date back to the 18th century. So I think more broadly, the idea of using the military to enforce immigration law is not only incredibly un-American, right? We do not have the military enforce the law within the United States. That is not what we do. It's also a brand new level of anti-immigrant policy put out by this administration. The military should not be taking part in any of this. And the idea that we are going to, as a country, turn neighborhoods into police states in order to put forth and promote a xenophobic and racist agenda is something that everybody, regardless of how you feel on this issue, should be incredibly upset about.
Thank you.
Okay, unless anyone else would like to answer that question, we will turn to a question from Britton Eakin, a reporter with Law 360. She asks in the chat if there are any differences in degree between the current DOJ and ICE directives and what the Trump administration tried to do in 2018. Azadeh, I know you talked about Trump 1.0 earlier, if you want to be the first, and then anyone else can jump in as well.
I can just say very briefly, the situation in 2018 was slightly different because essentially Jeff Sessions announced that they were going to pull the plug on the funding, and we and partners were able to file suit, and there was extensive congressional advocacy as well, as I mentioned, and they reversed their decision, meaning that there was no disruption in services as a result. My understanding about the situation this time around is that it was more abrupt, without advance notice, and really providers having to stop providing services at the drop of a hat. So a bit of a different situation here, but defer to other panelists as well if they want to add.
I mean, I guess one thing I'd like to add that I do think is substantively different is that our experience, at least in the prior iteration of this, is that ICE was not receiving the same level of coordinated communication regarding disallowing access even under the detention standards. Because there is language in the performance-based detention standards that state that people, organizations that are legal organizations can provide these services. So while we were facing potentially a change in our funding structure, we were not facing the same level of lack of access that it appears we are currently facing, which is really concerning.
Thoughts, Michael? No?
Yeah, just to echo that, like last time around, Amika Center was able to get into a lot of the detention centers and still provide services without the funding. And the idea that this administration wants to even cut off nonprofits from helping is a whole new, again, another level of problematic. This is, as Laura said earlier, the most basic of due process that we are trying to provide.
Thank you. I would just want to remind members of the press that they can use the raise hand function to queue for the question and answer. Give it a moment to populate. But I want to ask a final question of Abdulaziz. Abdulaziz, you spoke powerfully about your experience in the legal orientation program when you were detained, simply for seeking asylum here in the United States. If you could say something to the administration to help them change their mind about this pause, what would you say?
So, America has built its greatness through the respect for the law and the respect for the fundamental principle which constitute, a guarantees and protection for everyone. And in everyone, I'm including immigrant, because the law is allowing people that are facing persecution to come and seek protection in America. People like me that loves America, people like me that during COVID refused to stay at home and take advantage of the system both in federal, level and state level, and have funds and stay at home. But like instead of that, I refused. I stayed, working. And at that time, I was working at 7-Eleven, working on a night shift from 11 p.m. to 7 a.m. And then I just decided to keep going work, make sure that coffee, make sure that donuts, make sure that hot food are ready for those heroes that were coming help our community, those firefighters, those police officers, those nurses, So that's immigrant too. And that's why, I took the liberty to include immigrant within the everyone. So posing the LOP is to me equivalent to saying that the due process is not working anymore, and that it is not efficient, and that it is not important. And I believe that this is not America. I might be wrong, I don't know. And I also believe that, America is better than that, and hoping that the LOP program will be back.
Thank you so much, Abdulaziz. We have a quick question from Felipe. Beyond lack of funding, have providers been physically barred from a presence at EOIR as well? Azadeh and Michael, I think, wanted to take this.
Yeah, I can
Okay, go ahead,
clarify
Abdullah.
I can clarify really quickly that actually I was just touching base with my help desk colleagues, and we haven't been physically barred. I can confirm that, at least in the Chicago court. I can't speak to other courts across the country. There's multiple help desk providers, and we are essentially providing scaled down and unbilled voluntary services to people who are approaching us at this stage.
Yeah, I don't have much more to add other than our team, our LOP team, who are amazing, were escorted out of the facility, but out of the ICE detention facility. But we have not heard anything about being blocked from entering the courts. Laura, have you heard anything?
Thank you. We'll have to take Alyssa's question as the last question. Go ahead, Alyssa.
Thank you. Sorry, just one quick follow-up as well. Do you have any understanding of when this pause may be lifted? And also how, if the pause is still in effect, your work will be impacted if, say, the Laken-Riley Act results in minors being arrested for things. Have we gotten that far in that conversation, or is it still too early? Thank you.
Laura, do you want to handle that one?
Yeah, so I mean, in terms of how long this will last, I don't think we have any information at this time, and that's part of a major concern. It is framed as a pause, but it is unclear what process is going to be followed. Immense harm that can be, heaped upon the people that we serve during the course of an indefinite pause is deeply concerning to us as organizations. And in terms of your comment regarding the Laken-Riley Act, I mean, again, this is part of the broader landscape that Andrew and others were speaking about that really reflects why this is so deeply concerning in this moment, because there are so many other factors at play that are bringing more and more people potentially into custody, more and more people potentially subjected to prolonged and indefinite detention, more and more people who could potentially really be harmed by the lack of any information or access in these facilities. And I do want to just flag also that some of the context of some of what we're seeing in terms of things like expanded expedited removal and things like that can also very easily sweep up people who are U.S. citizens, which is a very real concern. in the course of my career at the Florence Project, I've served numerous citizens who are already detained under much less broad and problematic sort of legal structures than what is currently being proposed under the executive orders that this administration has rolled out. And so I think we have to be very thoughtful also about how many people are going to be caught up in this net who really there's no reason at all that they should ever be there. I think, non-citizens and immigrants shouldn't be placed into these facilities in these conditions either, but there's absolutely no authority for immigration to be detaining U.S. citizens. Yet again, we have seen this in the past, and I strongly suspect we're going to see that in the future.
Thank you so much. Thank you, everybody, for our speakers, for today's press conference, and everyone who joined. If you do have any questions or would like to follow up with any of today's participants individually, please email media@amicacenter.org and be in touch. Thank you, everybody. Have a good day.